This regular meeting of the Montana Public Service Commission is now in session. The time is 1:30 p.m. The date is September the 3rd, 2019, and we are in the Bollinger Room of the offices of the Montana Public Service Commission in Helena, Montana. A couple of things before we go to public comment. First, I want to welcome Montana Public Affairs Network, who will be recording our gavel-to-gavel proceedings through the course of the interim. This very much in keeping with the Commission's commitment to increased transparency of our proceedings. We are certainly hopeful that this will give many more folks an opportunity to see the Commission in action, and we welcome that. Thank you very much for being here. Secondly, all of us up here have over time commented on the tremendous quality of staff that we have here at the Commission, and sometimes that recognition actually moves beyond the walls of the office here. And we have a situation with today where a staff member was recognized by the governor for excellence in performance, and I'd ask Mr. Rosequist to come up and make a presentation to Ms. Arnold. You don't get to sit back there. Come on.
No.
Thank you, Mr. Chairman. I would like to take a few minutes just to recognize Robin Arnold, this year's recipient of the Governor's Award for Excellence in Service as a public employee. Robin did outstanding work during the 2019 legislative session. She monitored all the bills that affected the commission, organized them, made presentations to the commission, presentations to the legislature, was a huge help to me personally in keeping track of all of that, and I'm sure provided great advice to the commission as well, if I can speak on your behalf. And so with that, Mr. Chairman, I would like to recognize Robin Arnold with this certificate of congratulations. Robin will be formally recognized at an award ceremony later in September, but we wanted to also recognize her here. So thank you very much, Robin.
Thank you.
Robin, let me also say that a number of legislators through the course of the session shared that same enthusiasm with regard to your performance in behalf of the Commission. So thank you very much for the good work.
Now, you agree with the governor one time.
Yeah. Moving on now to our regular order, we will take this opportunity to invite anyone who wishes to make public comment before the Commission to come forward and do so at this time. Is there anyone who wishes to make public comment before the Commission? Seeing none, we will move on to our agenda and begin.
Chairman, I just wonder if it would be appropriate this time to recognize a new member of our staff.
Absolutely, Mr. Kraske.
Mr. Chairman, Commissioners, thank you. I'd like to recognize our new Paralegal Commission Secretary. She started last Monday at the Commission, Vicki LaFawn Smith. Welcome to the Commission, and she'll be taking minutes today and going forward. We're very happy to have her here. Thank you.
Thank you, Vicki.
You want to make a welcome speech, Vicki?
No, thank you.
Moving on now to public comment. Is there anyone who wishes to make public comment? Seeing none, then we will move on to work session items, beginning with action items. Approval of minutes from the previous meeting.
So moved. Second.
Been moved and seconded. We approve those minutes. All those in favor signify by saying aye. Aye. Opposed, no. Motion carries unanimously. And that. And then action item number 2, an out-of-state travel request. Mr. Kraske.
Thank you, Mr. Chairman, Commissioners. Staff requests approval for Luke Casey to attend the Basics Regulatory Training Course in Albuquerque, New Mexico from October 14th through the 18th of this year. For the Commission's information, this is a training course that we usually send new staff members to. as available. This is a great course. Mr. Duncan at the commission also teaches at this course, the revenue requirements. We had anticipate the cost to the commission for the out-of-state travel to be around $2,000 between the registration, the hotels, and the flight to get there. It's a great course for new staff members. Staff requests that the commission approve Luke Casey to attend this course in October. Thank you.
Is there a motion to that effect?
Mr. Chairman, I move that we approve the travel request.
Is there a second? Been moved and seconded. We approve that request. Discussion of the motion? Hearing none, I'll call the question. All those in favor signify by saying aye. Aye. Opposed, no. Motion carries unanimously. Thank you all very much. Mr. Casey, you're in for a great experience. It's a good program, and I'm glad we're going to be able to get you there. Great. All right, moving on now to work sessions, beginning with docket D 2010.06.060 North Star Planned Unit Development. Well, Mr. Casey.
Good afternoon, Commissioners. So before you in docket 2010-06-060 is a petition for late intervention from Aquaflow. Aquaflow, to my knowledge, is another distinct water utility that is being provided with sewer services by North Star. In other words, they're a customer of North Star. In other words, they're directly impacted by North Star's application, and have indicated that they did not receive notice of North Star's application. Staff believes that that's a demonstration of good cause as to why they failed to timely intervene. If you'll note from my email last week, they intervened about a week after the deadline. Staff's recommendation is to grant Aquaflow's petition for late intervention.
I would move we grant late intervention to Aquaflow.
Second.
Is there discussion of the motion? Commissioner O'Donnell.
Just a quick question. Is there any way that being a downflow sewage, but downflow from them, that they should have been? Did we miss something on that, or did we have any knowledge of who they were or how they were connected so that they would have been notified on a timely basis?
Chairman Johnson, Commissioner O'Donnell, if I understand your question correctly, I don't think this is a failing on the Commission's part. I think that what Aquaflow is alleging is that North Star, in disseminating its notice to its customers, never gave notice to Aquaflow, which is a customer of North Star.
Sure.
Does that answer your question?
It does. Thank you.
Okay.
Is there any further discussion? Hearing none, call the question. All those in favor signify by saying aye. Aye. Opposed, no. Motion carries unanimously. Thank you, Mr. Casey. Work session item number 2 is docket D 2018.02.011 Miller Oil Company.
Good afternoon, Commissioners. The purpose of this work session is to consider the approval of Miller Oil's application for its annual true-up of its propane cost tracking adjustment. All in all, the docket is pretty straightforward. If you have questions pertaining to the application itself, I'll probably direct you to Grant. But there is one wrinkle with regard to this docket, and it's Senate Bill 244. If you'll recall, that bill requires that any tracker approved subsequent to the date of approval of the bill, which is already in effect, that those trackers have to be uniform utility-wide or from utility to utility. So our recommendation in this case is that and our recommendation in subsequent tracker cases this year will be to approve these on an interim basis, to sort of put something in place as a placeholder pending the Commission's final resolution of how it's going to implement Senate Bill 244. So this gives the utility some sort of certainty moving forward as to how this case is going to be resolved, and allows us to put this to the side for a moment and then resolve Senate Bill 244. So our recommendation is to approve the Miller Oil tracker application as presented, and we're available for any questions.
Is there a motion? Vice Chairman Lake?
Mr. Chairman, I would move that we grant the interim approval of the cost tracker for Miller Oil.
Is there a second to the motion? Been moved and seconded. We grant interim approval. Discussion of the motion.
You know, Mr. Chairman, I think it's just more of a comment, but I find it a little bit, after sitting in those chairs, I understand how it can happen, but for the legislature to pass on a requirement to us of which in many cases do not work like they had planned for, and nor do they affect the people that they do affect the people, but they include a lot of others along with it. But we will take care of it with our rulemaking authority. Sure.
Is there further discussion? Commissioner Koopman.
I support the motion. It's unfortunate we have to kind of jump through these hoops, and I suppose I'll be a little less charitable than Commissioner Lake. I too sat in for 2 terms in those chairs in the legislature and the House side, and I think I would simply note that these kinds of complications and what do they call them later, unforeseen consequences or whatever, can be avoided if there is better communication between the legislature and commissioners. Commissioners certainly made themselves available, as did staff, and tried to reach out to the legislature. Yes, they're in a crunch and all that sort of thing, but and this bill was heavily lobbied by certain interests. But something that's this technical and this complex, the legislators really do need to seek authoritative sources before they cast votes, because this thing has turned into a mess, and we had basically warned them it would. So, but I do support the motion, and I can only hope that legislators maybe learn a little something from this.
Thank you, Commissioner Koopman. Is there further discussion of the motion? Hearing none, call the question. All those in favor of the motion signify by saying aye. Aye. Opposed, no. Motion carries unanimously. Thank you, gentlemen. Moving on now to work session item number 3, docket 2019.08.046, Northwestern Energy.
Thank you, Mr. Chairman. On August 7th, Northwestern filed a petition with the Montana Public Service Commission seeking authority to issue up to $1.1 billion in securities from the date of this order through and including September 30th, 2021. This is the same request they did 2 years ago on the previous docket in D 2017-867. And every 2 years they come in and ask for this security stuff. If you recall, I think it was 2 weeks ago, we approved something similar to this for MDU. The commission noticed the petition and did not receive any parties looking to participate. Northwestern states it will use the proceeds from the security to support state-regulated capital expenditures, acquisitions, state-regulated assets, and refunding or repayment of its outstanding obligations. This order was superseded and replaced the order number 7565 in docket D 2017-867, and staff would recommend approval.
Vice Chairman Lake.
Mr. Chairman, I would move that we approve Northwestern Energy's petition to issue securities.
Been moved and seconded. We approve Northwestern's request. Discussion of the motion. Hearing none, call the question. All those in favor of the motion signify by saying aye. Aye. Opposed, no. Motion carries unanimously. Thank you, gentlemen. Now, work session item number 4, commission initiated in docket 2018.10.068. Mr. Rogala.
Thank you, Chairman Johnson. I don't have a theme for this docket. This work session is mostly a procedural one. You'll remember that the first week of August, we held a work session to issue a revised order to compel responses in the Northern investigation. After that work session, we had a pretty lively discussion out in the hallway with representatives from Northern and the Commission on next steps. Subsequent to that discussion, we received their motion to reconsider that order to compel responses, seeking a variety of different relief from the initial order. The purpose of today's work session is to do 5 things. First, it is waiving the 20-day deadline within which the Commission must issue a decision on Northern's motion for reconsideration, and that's waiving the 20-day deadline in our Regulation 38.2.4806, subsection 5. Second, Northern requested oral argument on their motion. I think that's helpful because the issues involved are quite technical, and I think the Commission will benefit from oral argument on this issue. So we'd like you to grant Northern's request and then direct staff to reach out to Northern to determine sometime in September that works for oral argument with our calendars. Third, staff would recommend that the Commission stay a decision on Northern's motion, obviously till after oral argument. That's just the follow-up to oral argument. But importantly, for Northern's perspective, they requested a stay of their deadline to respond to the initial order to compel responses. That deadline is the 6th. If we don't lift that deadline, then their responses are due on the 6th, and I think it's entirely reasonable to suspend that deadline pending a resolution of the motion to reconsider. Importantly, Northern asked for a stay of their production of documents until after the district court litigation is resolved. That issue isn't on the table currently, but we'll address that one on final resolution of their motion for reconsideration. So staff's available for any questions. Thank you, Chairman.
Commissioner Panocci.
Mr. Chairman, I recommend that we approve staff recommendations.
Been moved and seconded. We approve staff recommendation. This docket discussion of the motion. Hearing none, call the question. All those in favor signify by saying aye. Aye. Opposed, no. Motion carries unanimously. Thank you, Mr. Rogala. We are now work session item number 5, docket 2018.09.063, HLH LLC. Mr. Kraske.
Thank you, Mr. Chairman, Commissioners. I'm handling this work session today as I haven't been actively involved in the HLH matter, and because exceptions were filed involving the proposed order by the Commission, I'll be presenting that with Mr. Fink here today. So as the Commission is likely aware, the hearings examiner, Commissioner Koopman, issued a proposed order as there was less than a quorum of commissioners that heard the matter. That was issued on July 16th of this year. That approved a stipulation between HLH and MCC. Once that order was issued, the Commission received HLH's exception to the proposed order. They brought up one issue involving paragraph 29 that was included in the order. They state, paragraph 29 states that HLH has engaged in and will likely continue to engage in material affiliate transactions as defined by 69.3.1501 of the Montana Code Annotated. It talks about the definition of material affiliate transaction and also involving a regulated energy utility. They correctly pointed out in their exception that a regulated energy utility does not cover a water utility or sewer utility such as HLH. The Commission has several administrative rules that deal with applications for rate increases and concerns about affiliate transactions. Specifically, I'll point the Commission to 38.5.102 for a rate application exceeding $100,000. Forms shall be submitted, including work papers defined in 385180, which covers purchases from affiliate companies. It indicates if any of the preceding statements cover major purchases or major transfers from an affiliate that is not regulated as to price, the applicant shall submit an explanation of the price associated with the purchases or transfers. So I bring that up as staff recommends that the commission issue a final order consistent with the proposed order, but amend paragraph 29 to strike 69, 3, 1501, and 1502 that's discussed in there, and focus instead on our administrative rules that require utilities to provide work papers and documentation involving purchases from affiliate companies or transactions. And going forward, we would indicate in that portion of the order that the utility, the water utility and sewer utility needs to maintain records involving affiliate transactions consistent with the administrative rule. And if the commission has further inquiries or the utility files a future rate case proceeding, the utility is required to maintain those records for commission review. Therefore, staff recommends that the commission issue a final order consistent with the proposed order, with the exception of amending paragraph 29, as I stated, to remove the Montana Code references and instead cite to the administrative rules for rate cases. Mr. Fink, did you have anything else to add? Chairman, that would be our suggestion. Thank you.
Commissioner Koopman.
Yeah, I would move that the commission issue a final order that is consistent with the proposed order. So in other words, I would move for the approval of this final order with the exception of amending paragraph 29 to remove the references to the Montana Code annotated 69.3, 1501, and 1502, and to instead include an update that would reflect the Commission's administrative rules for rate cases. Would that be sufficient, Mr. Kraske, to cover this?
Thank you, Mr. Chairman. Commissioner Koopman, that would be correct. Thank you.
Very good. Thank you.
Been moved and seconded. We adopt staff recommendation in this docket. Discussion of the motion, Commissioner Koopman.
Yeah, just briefly, I think staff did a great job in writing the order. Of course, we were following a stipulation, but just looking through it, it's very thorough and very good. And this is essentially a technical but important correction in paragraph 29. It shouldn't be controversial, Mr. Chairman.
Further discussion of the motion. I think we should point out the remarkable job that the loan commissioner did chairing the hearing. If there's no further discussion, we'll call the question. All those in favor of the motion signify by saying aye. Aye. Opposed, no. Motion carries unanimously. Thank you, gentlemen. All right, where the heck are we? We are now to work session number 6 in docket 2018.08.053, another commission-initiated docket, this having to do with rulemaking for discovery. Mr. Rogala.
Thanks again, Chairman Johnson. This one has two themes. The first one is about time, referring to the Commission's delay in reforming its discovery rule, given various parties' concerns with our data request process under our regulations. The reason it's called about time is because we just recently received a Montana Supreme Court decision which reversed a district court's opinion that had called into question the Commission's discovery process. That decision is now reversed and the matter has been remanded back to the Commission, so we feel we now have space to move forward with our discovery rulemaking. So it's about time. It's also, the theme is lipstick on a pig, because to some of the parties, I think they're going to view our vision to our discovery rule as not resolving their due process concerns. And staff recommends with this, acknowledges with this notice of rulemaking that that is the case, that we think their due process concern will still exist. However, very importantly, it resolves the issue of the language of our regulation, which what we're doing here is clarifying that the commission, staff, and hearings examiners can engage in discovery, and linking that practice to the rules of evidence, which specifically provide for commissioners or the court in the rules of evidence to investigate witnesses, to call witnesses, and to interrogate as necessary. So I just want to provide a brief overview of the next steps. Staff recommends issuing this notice of rulemaking to be filed in the Secretary of State's Montana Administrative Register by September 10th. After that is published in the Register, I think later in September, we will have a hearing October 29th. After that hearing, we will receive public comment on the proposed revisions, synthesize those comments, make a final decision on the language of our discovery rulemaking, and file that decision with the Secretary of State. I think that's a 4 to 6 month process from today. So this is the start of the process, but staff is available to answer any questions you have about the draft language currently and what the next steps are. Thank you.
Commissioner O'Donnell, you've not made any motions yet today. You want to offer a motion here?
I would like to ask questions before motion, Mr. Chairman.
How about you offer the motion, we get a second, then we discuss the motion?
So moved.
Been moved and seconded that we approve staff recommendation in this docket. Commissioner O'Donnell.
Thank you. So in reading this over, I think I understand a lot of the technical lawyer talk on the whole thing. But what I don't really see on here is if two things are being solidified and maintained, and one is that unlike, as I've said before, unlike a regular judicial proceeding where it's guilty, not guilty, or for the defendant, for the plaintiff, that our job is to seek out something other than one side or the other. Avoided cost is an example of that. We have to determine what it is, not judging between two different parties. So as long as we have the freedom and the flexibility to do that, I think that is important. One thing in here that I think it was in this discussion here is that recognizing that the commission is quasi-judicial in nature, but also quasi-legislative in nature, and I hadn't seen that before, and I appreciate the inclusion of that. So we are a strange hybrid creature relative to the judicial system and other agencies, and I think that we have not been shown we haven't been shown that respect, but that character has not been respected by the people who have criticized us. So I'm glad that we have an opportunity to solidify this. One thing that I wasn't certain about, during a contested hearing, will commissioners still have an opportunity for verbal questioning of witnesses? It seemed to be, I saw something in here, the commissioners would have the ability for pre-hearing discovery, but is this still retained?
Chairman Johnson, Commissioner O'Donnell, I think that's a good question and something that we had contemplated with the language prior to an evidentiary hearing. Because during the evidentiary hearing, we're not engaging in discovery, we're engaging in evidentiary cross-examination. That being said, I think it presents an argument that parties could raise if they like, but I don't think that it's that substantial of an argument to warrant including in this rule language. But what we can do, importantly, is include that issue in our reason for amending and saying, this discovery pre-hearing practice in no way restricts the commission's right to engage in evidentiary hearing cross-examination. And that'd be a good way to kind of dovetail that issue. And I think it's important to note that this concern with the commission's discovery process is a longstanding issue. Former commission attorney Dennis Lopatch wrote the discovery rule in 1977, and you can go read the administrative registered notice from 1977, and he states that the definition of party in subchapter 6 affords the commission staff the rights and responsibilities of a party while exempting them from the prohibition of ex parte communications with the commission. Mountain Bell's, then the telephone company, Mountain Bell's comments suggest that this raises due process problems. Existing case law, however, suggests that such treatment is permissible and not violated of due process standards. Further, the limited number of commission staff prevents the separation of functions enjoyed by many federal agencies. So I just think that's appropriate to respond to your first point about the commission's quasi-legislative and quasi-judicial powers in the same proceeding. So this is an issue that's been out there for a while, the due process concern, but it hasn't been resolved by the court.
Yeah, it is time to resolve the issue, and whether or not we can do a permanent, applauded by all resolution, I don't know if that's possible, but we do need to get it resolved because as I read through testimony, pre-filed testimony, certain questions come up, and then during the hearing when people give information, then again questions come up that never occurred to me before. So it wouldn't have been something that I could ask staff to put into pre-filed testimony. It's just things that come up, and it seems to me it's the nature of the staff and the commissioners to look for something other than a purely numerical or legal finding on something, but something of the Shakespeare called it the quality of mercy, but the quality of judgment of what is fair. And so this is a deliberative process, not necessarily a mechanical thing where you say, just do if statute A, B, and C are fulfilled, that there's much more to it than that. And I would feel very, very frustrated in my job doing the right thing if I was constrained by not being able to pursue to answer certain questions. So, Mr. Chairman, thank you.
Thank you, Commissioner. Further discussion on the motion, Commissioner Koopman.
Yeah, just a question or two, because I really have been sensitive to this issue all along. I remain unpersuaded that there really is a due process problem here, but there might be, and I've always been sensitive to, I guess you'd say, the overreach of administrative agencies and exercising too much authority. I think it does need to be said, for the record, that I don't, in the 6.5 years I've been on this commission, I've never seen the discovery process ever abused. It's never been used as an advocacy type of function. We've never put ourselves in an advocacy position. We're simply helping to build the record, the administrative record. But I guess a question, in other states, has this been tested? Do other commissions, public service commissions, or whatever they call themselves, utility commissions, Do they have a pretty active discovery process, particularly pre-hearing, evidentiary hearing? Or is it very different from state to state? It sounds like it hasn't been a settled matter before SCOTUS, but what's going on out there?
Chairman Johnson, Commissioner Koopman, this issue was presented in the Merrimont PJR, and at that time, we reached out to a variety of different commissions to get a litmus test of how our practice stands to others. And other state commissions are all over the map. Many separate the functions of investigation and decision-making entirely, where they have advocacy staff that participate in dockets, file testimony, engage in discovery, and the deciders, either hearing examiner or a full commission, make the deciding functions. That's typical in larger states. In smaller states, you see a variety of combinations of functions. However, I can only think of 2 states off the top of my head that have a process very similar to the Public Service Commission. I can't remember those states off the top of my head. I'm sure Northwestern may indicate the differences between those processes and ours, but I think they're substantially similar. But to the point, federal case law has considered this issue a variety of times, and they recognize the unique nature of administrative agencies that combine these functions in a regulatory setting, and they say it doesn't result in a per se due process violation. Rather, it depends on the facts and circumstances. That being said, state constitutional law is a different matter, and that's still an open question in Montana.
Okay, I appreciate that. And of course, there was a kind of a crazy quilt bill in the last session of the legislature that didn't pass that it tried to address some of this, and I'm personally glad that it didn't pass because it was a mess. But and we obviously don't need to discuss this anymore now, but do you still feel like there might also be a legislative solution out there too to even clarify this more, or would these rules potentially settle the matter?
Commissioner Koopman, I think that parties would have a similar concern with a legislative fix as they could with a regulation fix, because due process trumps the statute and regs. And so if they have concerns about the commission combining functions under the Constitution, that needs to be resolved by the courts.
Okay. Well, I support the motion. Obviously, the final product could look significantly different, but you've done good work on this. Thank you.
Is there further discussion of the motion? Hearing none, call the question on the motion. All those in favor signify by saying aye. Aye. Opposed, no. Motion carries unanimously. Thank you, gentlemen. Now to our last work session, having to do with the implementation of SB 244. Ms. Arnold?
Good afternoon, Mr. Chairman, Commissioners. Just as a recap, Senate Bill 244 was passed in this previous legislative session. It went into effect on May 8th, 2019. And the bill states that if the Montana Public Service Commission approves a cost tracking adjustment for a public utility regulated in accordance with Chapter 8 or Chapter 3 of Title 69 in Montana Code annotated, the cost tracking adjustment must provide for identical treatment of public utilities subject to either chapter, require 90% customer and 10% shareholder sharing of costs if cost sharing is required, and provide full recovery of costs incurred by utility as a result of a qualifying facility purchase requirements. The bill also prohibits the inclusion of a deadband and cost tracking mechanisms. Staff has provided the Commission with a memo that outlines a number of different utility tracking mechanisms that the Commission has already approved for various utilities. And the main concern that staff has with this bill is the language that requires identical treatment of public utilities subject to Chapter 8 or Chapter 3 of Title 69. Chapter 3 of Title 69 is not restricted to electric utilities. It also covers electric, natural gas, propane, water, and sewer utilities. Therefore, this applies to a variety of different tracking mechanisms. Staff has listed a number of questions that we've raised that surround the identical treatment language, as well as also the full recovery of costs as a result of qualifying small power production facilities. Staff recommends that we initiate a study docket prior to launching into any rulemaking to implement this bill. That way we can get a written response from the utilities on these questions and also bring everybody together at a roundtable to initiate discussion on these questions.
Vice Chairman Lake.
Thank you, Mr. Chairman. I would move that we follow staff's recommendation and open a rulemaking docket so we can have discussion on how to implement Senate Bill 244. Okay.
Been moved and seconded, we adopt staff recommendation. Discussion of the motion.
Mr. Chairman, and I appreciate the efforts of the commission or of the legislature, but this is one thing that the simple inclusion of like scope, like direction would have solved all the problems. You know, keep all the electric utilities in one, gas in another, propane. And it may be as simple as that when we get done with the discovery that we're going to go through. So, thank you, Mr. Chairman.
Thank you, Mr. Vice Chairman. Further discussion of the motion? Hearing none, call the question on the motion. All those in favor signify by saying aye. Aye. Opposed, no. Motion carries unanimously. And with no further business to come before this commission, we are adjourned. Thank you all very much.